A major ruling handed down today by the United States Supreme Court in a 5-4 split decision. The court ruled police agencies can now collect a person's DNA without a warrant at the time they're arrested, much like fingerprinting, instead of waiting until they're actually convicted of a crime. 24 News 8's Mark Thompson has been working to learn what the fallout could be here in West Michigan. He has reaction from both sides of the controversial ruling. Mark?
Well, Marley, those opposed to the ruling say that it's yet another erosion of your Fourth Amendment privacy rights. However, law enforcement officials say that it helps them because it helps them putting a close to some of those unsolved crimes. No warrant needed. Even while presumed innocent, the Supreme Court ruled that police can collect your DNA at the time of arrest. Justice Anthony Kennedy wrote for the majority, saying, taking and analyzing a cheek swab of the arrestee's DNA is like fingerprinting and photographing, a legitimate police booking procedure that is reasonable under the Fourth Amendment. A ruling Michigan State Police wholeheartedly supported, saying DNA at arrest will give them more opportunity to check against unsolved crimes versus collecting from the already convicted.
We respect individuals' privacies, but you have to balance the rights of privacy against public safety.
The American Civil Liberties Union says the ruling is a major blow to Fourth Amendment privacy rights, arguing if you're going to collect DNA from the innocent, you must have individualized suspicion they committed a crime instead of just running their DNA to see what matches.
Nothing more private than our DNA, and the idea of a large government database of DNA is really very concerning.
Justice Antonin Scalia wrote a fiery dissent for the minority, warning about the erosion of privacy rights, saying this will solve some extra crimes to be sure, but so would taking your DNA whenever you fly on an airplane.
Or take your DNA so that you could get a driver's license. The logic of this opinion of the majority is that the government could do that.
State police say they would only collect the DNA of people arrested for felonies, and pending state legislation, it's possible they would return the samples if acquitted. In fact, Michigan is one of 26 states already collecting DNA from arrestees of specific violent crimes.
We do now collect them on felony arrests for violent crimes now already.
And this all stems from a Maryland case where a man was arrested for assault but convicted of rape based on collected DNA. Reporting live from the Kent County Jail tonight, Mark Thompson, 24-hour News 8.
And you know, Mark, Target 8's been following this. Isn't there already a backlog processing DNA at the State Police Crime Lab?
Well, Marley, that's a good point, and the ACLU brought that up because they're concerned about what that would do for due process in the court system. Well, MSP says that they're hiring more scientists to try and speed up the process of getting that DNA through the system.
Sure, we'll be hearing a lot more about this. Thanks, Mark.